Good evening and welcome to this public hearing of the Standing Committee on Social Development. My name is Jane Wayellen Armstrong. I am the MLA for Mofi, Cleature Region, and Chair of this Standing Committee. At this time, I will ask members to introduce themselves. Starting to my right.
Good evening. I'm Shauna Morgan, the MLA for Yellowknife North.
Good evening. I am Kate Reed. I am the MLA for Great Slave, and I am happy to be here as a guest to this committee.
Good evening. My name is Danny McNeely, the MLA for the Sawtooth region. Thank you.
Okay, we're doing the introduction. Introduce yourself, please.
George Nearsu, the MLA for the Mackenzie Delta riding.
Thank you. Bill 40, an act to amend the Vital Statistics Act, received second reading in the Legislative Assembly on February 11, 2026. Bill 40 proposes to change the Vital Statistics Act and the Change of Name Act to reflect notions about gender and family structure, and in particular, non-binary people, transgender people, and multi-parent families. This committee has been tasked with reviewing the bill to see if it needs changes, and if it has any issues we can solve, and if it is ready to continue on its path to becoming a law. That is our role in this process. We did not write the bill, but we are in charge with taking a very close look at it and making sure this bill represents the wants and needs of residents as best we can. This evening committee will hear from the Royal Canadian Mounted Police G Division, followed by the Northern Mosaic Network. I want to remind all witnesses that the proceeding will go through me as chair to keep the meeting running smoothly. At this time, I would like to turn the floor to the RCMP. Please proceed.
Thank you, Madam Chair. It's a pleasure to be here again. I'm always honored and feel privileged when I'm invited to speak on behalf of the RCMP, so thank you. This might actually be one of the shortest presentations I've done because I was speaking with Chelsea on the way in here, and it seems that some of this information may already have mechanisms in place, but I still want to present it and ensure that our position from the RCMP is at least put on the record and understood so that things aren't missed. So with your permission, unless there's any questions or any concerns before we get going, I do have a slideshow I can start with.
Go ahead.
Okay. Okay, so the purpose is to provide information regarding public safety and in relation to potential amendments to the Vital Statistics Act. The topics are concerns, current notification processes for the RCMP, as well as a practical example. So the provision that does raise concern for us comes at number 18 sub 4, which states notwithstanding sections sub 1 and sub 2, the Registrar General may decline to publish notice of the change of a name or of a person or provide it to any authority that is, if satisfied that the change is minor in nature, B, the person is commonly known under the name applied for, C, the reason for the change relates to a person being transgender, non-binary, gender diverse, or two-spirited indigenous, or D, the publication of the provision of notice would cause undue hardship. Where it raises concerns for the police of any name change in which that clause states publishing to the authority, to any authority. For the police, that poses a problem when it comes to both past and current judicial records. So all of our records are linked to specific legal names. And that's on the CPIC database. So that is the criminal record database that is managed through the RCMP but not owned by the RCMP. And that's a national database that is from coast to coast and is utilized in conjunction with international partners as well. Even a minor change in one's name, if there was a failure to provide notification or proper notifications even of minor changes, that could cease the linkage to be valid anymore. This would include records including past violent behavior towards not only members, RCMP members, but also members of the public. And so those, if they're not linked, they could easily be missed when we have somebody either in our custody or somebody we're approaching to deal with. This also could include outstanding warrants, current release conditions, and warnings that have been placed on the system to keep everybody safe. Errors in names could also render judicial orders invalid, requiring delays in an already overburdened judicial system, requiring us to have to redo paperwork and reserve them. So that means court appearances could be adjourned and causing further delays. And in more serious cases, it could completely jeopardize the integrity of court proceeding. So the current notification process, I've put an example up here on the screen. We will receive a letter from the vital statistics regarding a list of anybody who's had any name changes or modifications. And this is an example of what it would look like for us. So you'd have the original name, gender, date of birth, the community of residence, and then the new name. And if it's applicable, any change in gender. The date of birth usually doesn't change because that's locked in time. And then the effective date. Where this becomes very problematic if we don't receive these notifications, and what I've done here is I've condensed a very lengthy example. So this is an individual who lives up in Inuvik. And if you'll see up at the top, it's kind of hard to see from here, but there's something referred to as the FPS number. That is fingerprint section number. So anyone who has a criminal record or has had their fingerprints taken for the purposes of the judicial process will be assigned a fingerprint section number. And it's unique to every person. And it can only really be verified through fingerprints. So in this case, this individual, he's currently facing outstanding charges right now. He's also the subject of 1, 2, 3, 4 firearms prohibitions from different years and different very violent offenses, a lot of sexually based offenses as well. He's also on 1, 2, 3, 4, 5 probation orders, all running concurrently and all with some various conditions. And so all these are on a database that we can access whenever we come into contact with an individual or someone's called about an individual. All of these, including past and current conditions, help form a risk assessment when dealing with an individual and will flag people for violence, especially violence towards police if they've ever had resisted arrest or assaulted police officers. That's all on the database, and that comes up as warnings for when you're about to deal with someone. Now, if somebody changes their name and there's no notification that comes into the RCMP for whatever reason, that linkage will not be changed because we will have no idea that it needs to be changed. So in the case of this individual here, If that person was to undergo a name change and for whatever reason we weren't notified to make the linkages, we wouldn't know that this person is the same individual. Given the transient nature of our territory here with the police officers, that is very problematic because most police officers stay about 2 years in a community, so that knowledge of the community transfers with them. So we really rely on these databases to inform especially our new members of potential threats, as well as any conditions that they should be monitoring. So if somebody all of a sudden changes their name and we don't have that linkage, when they run the new name, it could come up as basically a clean slate for when we run their names. So just as a final consideration, now from our perspective, the requirement for that provision where there could be a concern for that information getting out, I want to point out that there are already provisions under both territorial and federal privacy regulations that prevent us from releasing that information and showing that link. That's all safeguarded and protected information. The only thing where it might show up is if there's new charges and that becomes public record, but that's not for the police. That's not what we do. That's through the courts. That is our only concern with this, is that if there's no notification for us, then we can't modify the linkages, and basically the past stays concealed, even though it still is the same individual. Thank you, and if there's any questions, I'd be more than happy.
Okay, thank you. Committee, are there any questions? Okay, we'll go to Shauna first.
Thank you, Madam Chair. So what's confusing is that it seems that your position today is that there should never be a situation where the RCMP or an authority is not provided with notice. But in our current act, just the way it stands right now, in the Change of Name Act, it already states that the Registrar General may decline to provide notice of the change of name to an authority if it's satisfied that, there's one of three conditions. The change of name is minor, the person's been commonly known under the name applied for, or this would cause undue hardship. The only change that we're actually contemplating in the current bill is just adding a fourth sort of bullet to that list that specifies that another reason the Registrar General could decline to provide notice to the authority is if the reason relates to the person being transgender, non-binary, gender diverse, or two-spirit indigenous. So it's confusing why you would raise these concerns now, just when the change is specifically only to do with a person being transgender, non-binary, the things I just listed. Can you explain, if you know, how does the RCMP cope with the current state of affairs, with the current legislation, which is that already the Registrar General may be declining to provide notice to the authority if, those other reasons are satisfied? Do you happen to know if there's current workarounds or ways of figuring out if there's already a criminal record, how it might be transferred to someone who may have changed their name? Do you have any knowledge of what the system currently is? Thank you, Madam Chair.
Okay, thank you. Chief Superintendent Smith?
Thank you for the question. Unfortunately, when the bill was drafted or amended the last time, we weren't included in this. This is something we certainly would have flagged years ago. And unfortunately, that seems to be the case with a lot of the legislation we have up here, is that we didn't have these types of opportunities back in the day. I can tell you right now, if I had been in my position when this was originally drafted, I don't know what year it came into effect, 2008? I can tell you right now, I would have had the same concerns with any provisions that might make it so, even through an error or whether it be an opinion, that the RCMP wouldn't have been notified of any change to a name. Now, having said that, I'm not aware of any circumstances, at least in my time here, where we haven't been notified. So again, if the provisions are there and it's not being utilized, then I fail to understand what the purpose of this would be. Having said that, it's important to remember that the workaround, as you would put it, isn't very simple, and it would be after the fact. So if somebody gave a name that wasn't reported to us, and I go and say, hey, I just arrested Dyson Smith, and I brought him in, and through our booking process, we run his fingerprints, then all of a sudden, the fingerprints don't change, so all of a sudden it would pop up as, hey, Dyson Smith actually has a huge criminal record, although when you run Dyson Smith, nothing pops up. That's because Dyson changed his name. It used to be Lyle Smith. That's my middle name. So, but that's the only way that we would be able to confirm is through fingerprints. But that's after the fact. That's after we've dispatched our officers to the call. And if Dyson Smith has a very violent past towards police officers or the public, they might be unaware, or Lyle Smith, they would be unaware until they run those prints at a later time. So unfortunately, that is the only way that, unless somebody was to say, oh, I recognize this person, that's not their name or whatever. Yeah, that's the only way that you can actually confirm that, and unfortunately, it's after the fact. However, if we got the notification right at the beginning, we would make the modification on our system to say that Dyson Smith and Lyle Smith have that same FPS number. Because again, the fingerprints don't change, and that's the only way to link the two in our system.
Thank you. MLA Morgan, go ahead.
Thank you, Madam Chair. I'm curious to know how you cope currently with, like, when people, say you pick somebody up, arrest somebody, they may not have ID on them, they may not even own a driver's license. I'm probably fairly sure no one carries the birth certificate around with them. So in terms of identifying what someone's name is, whether currently you just sort of ask them their name and they tell you and you believe them, or like how you even verify currently what someone's official name is. Also given the fact that many people go by nicknames. Maybe on their driver's license it says they're James or something, but actually they go by Jackie, and that's maybe how they present themselves. Even if they're not trying to be, trick anybody, but it's like, well, this is what I go by. So how do you even currently assess officially what someone's name is to know for sure in your system that someone's always going, by the same name, or that you know exactly who you're dealing with? Thank you, Madam Chair.
Okay. Chief Superintendent Smith.
Okay. I'm so used to reaching over and trying to press the button. There are many ways of trying to determine somebody's identity. Just speaking with them sometimes is enough, because you'll be able to piece enough information to confirm who they are. Because if you give the name Dyson Smith and we start talking about past events, or they should link up. Also on the system, when people are convicted of crimes, or when they're booked and stuff, there are various descriptors that are taken down and they're added to the system as well. So if I had a tattoo on my hand of a devil, that would be on the system saying that Dyson Smith has a tattoo of a devil on his hand. So if I saw on that the individual on his left hand, he has a tattoo of a devil, it's very likely that's probably the same individual. But there are times where we have to detain people because we can't confirm their identification. And so we have to take them into custody, and then we will run the prints and determine one way or the other who they actually are. But again, I'm less concerned with the after effect or of not notifying someone, because we can find out who people are eventually. I am very worried about the onset, though, when we dispatch our officers to a call and we don't know the full history of someone that we're about to send the men and women into, who could have they could be on the system as a police hater. And, we have people on our system that will flag them as police haters because they've openly said they want to kill a police officer, and that'll be flagged. And that certainly goes to developing your risk assessment anytime you go to a call for service. There's risk assessments and everything. Past criminal behavior, behavior towards police, types of violent behavior that people have done, whether or not they're prohibited from weapons, because that says a lot. So without those flags, though, we are walking into the unknown. And of course, we're trained and we prepare for just about anything, but having as much information at your disposal to better prepare our people for engaging with potential suspects and potential violent suspects is far more important, in my opinion, than worrying about if we can find out who they are later, because we can always seem to find that out, mainly through the fingerprint system. But I am very concerned, though, about any potential legislation that would make it so that through an error or through an opinion that someone would decide not to notify the police that somebody has changed their name.
Okay, thank you. Ms. Yakalai, MLA Yakalai.
Yeah, thank you. So you get a call, somebody said Dyson Smith is doing this behavior and they need an RCMP officer, so you go there and you find out it's not the Dyson Smith you thought it was, but it's somebody else. So that's where you get the prints later on to find out that. So you could be potentially sending yourself or your officers into a place where it's not safe for them, because you think you know it's the Dyson Smith you knew, but when you get there, it's somebody else.
Absolutely.
So that's why you need even if you were to know that the name got changed, you wouldn't know it right then.
Thank you.
Yeah.
Chief Superintendent Smith?
No, that's correct. We would still have to wait for the notification. But I look at it as getting even late notifications better than getting no notification. Because, we all have to work within systems, and, it would be great if everything was instantaneous. I would love for everything to be electronic, and as soon as it happens, all the pieces fall together, but unfortunately, that's not the reality we live in. But you're absolutely right. Sometimes we do run into that where there's two Dyson Smiths, and we're dealing with this one. We think this is the right one, but we confirm after the fact that this might not be the right one. So then we go and search for the correct one. But again, it really comes down to being able to perform a proper risk assessment. And that's fundamental with our training as well. So we train our police officers to do proper risk assessments, and part of that risk assessment is the criminal database. And if it's not accurate, then we are setting our police officers up for failure, or potentially.
Okay. Thank you. MLA Yakalai, do you have a follow-up question? No? Okay. MLA McNeely?
Yes, thank you, Madam Chair. Thanks for your presentation and your presence here this evening. I'm just looking at it to try to realize, and I do realize the harm that it may bring in various ways of misidentification here. Let me ask you a question. What confidence would you have in a new article to this legislation to provide some guarantees that the name change can go ahead, but we will be notified? Thank you.
Thank you. Chief Superintendent Smith?
I would be very confident in it, to be honest with you. If there was a provision that says, except for the police or what have you, I would be confident in that, because we have to abide and trust that the processes work. My only concern was when I read that, and it says that they can make the decision not to notify us. There should never, in my opinion anyway, and on behalf of the RCMP, there should never be any circumstances where we're not notified of a name change. Because, again, we're the ones that have to enforce those laws. We also have to make sure judicial processes are running smoothly for the communities or whatever you. So without that ability to make the linkages, that becomes very problematic. And it can also work in the opposite way as well. We're always maintaining these databases. Which also means that if we don't have the current or proper information, sometimes warrants get left on a system, and we might end up arresting Dyson Smith even though he doesn't have a warrant anymore because there was a mistake made and it wasn't removed. So we have to be able to trust in the systems and the information coming in. There's always a margin of error. But for the most part, the system is working as it should. And so, yes, I would wholeheartedly accept a modification or whatever that would say that the RCMP or the law enforcement will still be notified.
Thank you. MLA McNeely, do you have a follow-up question?
Yes, thanks, Madam Chair, and thanks, Superintendent, for your reply. We certainly want to keep our frontline workers safe and confident that legislation is not being passed to put them in harm's way by mistaken identity. And as a technicality on a name change, well, the whole case gets thrown out, and it's a waste of resources at that point. And it becomes a mockery of the system that somebody continues to play. And it seems that these are the advantages that are given to the criminals on how to get around and use red tape. So I'm just thinking, how can we provide and design some guarantees that it would make your staff and office satisfied? Thank you.
Thank you, Chief Superintendent.
Yeah, I appreciate that. I also want to state, though, that in all fairness, I've been doing this for over 25 years. Geez, I'm coming up on 26 soon. It's very rare to find someone who's changing their name because they're trying to evade the authorities or what have you. If they're a legal name change, I should say that. Yeah, quite often you'll have people give us fake names all the time. So I don't want to misinterpret this as that people who are non-binary or transgender or whatever, that anybody is trying to circumvent anything. That is not what I'm saying at all. I'm just worried that for whatever reason, that somebody has a name change, that in order for us to make sure that the enforcement tools that we have aren't jeopardized or the integrity of that system isn't weakened or diminished by a lack of notification. Because again, I think that probably 99.9% of people that do go through legal name changes, there's a very valid and honorable purpose for it. Again, it's just for us, it's not the why, it's just the mechanisms behind it when it comes to the notification for us. And that's all. That's the only concern. So, thank you.
Thank you. MLA Nurse, do you have a question?
Thank you for your presentation and being here. I know your concern is about change of names not being reported. I know there's a lot of Indigenous people that are reclaiming their Indigenous names, and I think some of them are just doing that like on their own, but they're still known as, you know, X, but the whole community has come to know them as this person. But how would you deal with somebody that, you know, if the chief or some leader of the community comes and say, no, you're looking for the wrong person. This is not Dyson Smith, this is Lyle. So, you know, I know your concern is about the change of names, but I know there's a lot of Indigenous families and even individuals reclaiming their Indigenous names. Now, it's something that, since we started talking about this, it's come to my attention that, you know, there is a lot of them even changing their names. I know a lot of them have criminal records that change their names too, and I don't know if it's legally changed or they just adopted those themselves. Thank you, Madam Chair.
Okay, thank you, Chief Superintendent.
So in situations like that, and in any situation where we'll have individuals that will utilize other names, and it doesn't necessarily have to be a legal name change, it's just they've decided to go by a different name. If they do get into trouble, what we'll do is we'll link an alias to that name. So until there's an official legal name change, that FPS number I was talking about will stick with, say, Dyson Smith. And then my alias on the system will be Lyle Smith, you know, because it's now known that I go by Lyle. But we can't change the database itself, the CPIC database with the FPS number, until there's a legal name change, because that's the only way to change it on that system. But we have lots of people with aliases and stuff like that. But when people are reclaiming their Indigenous names, that would be a very similar process where we would have Dyson also linked as Lyle. And then we also put on the system what the preferred name is, you know, so when we're dealing with them, then we start calling them Lyle, you know. But that linkage is always in the background back to that original criminal record. And so when we search, all of a sudden we get a call about Lyle. Lyle's out of control again, as he usually is. The system will flag that Dyson and Lyle are the same individual. So.
Thank you. MLA Nurse, do you have a follow-up question?
Okay, I posed this question to staff before, in terms of self-government agreements that do exist now and those in the future. These are federal legislations, these self-government agreement, and versus the NWT legislation, which is not very good. If a self-government agreement takes on the services of childcare services, and they don't want these, name changes or have these documents with 4 parents on it, and it's just, I'm just thinking of in the future, you know, I know there's a few self-government agreements, and I just don't know how it would reflect this, but it's not reflecting it right now because there's no actual legislation. But in the future, this self-government group, it will the federal legislation would supersede the NWT legislation, and you know, how doing a name change and the self-government group would, you know, they'll take on the childcare services and have their own legislation that's federally binding. So how would something like that, would you be able to deal with stuff like that?
Thank you. Chief Superintendent?
Yes, I'm sure we'd be able to work through, develop a process, probably no different than what we have right now. For us, it really doesn't matter which government we're dealing with. It's always developing systems to work within the regulations of that government that we're dealing with. So yeah, we always modernize and adapt and change, and this is another way forward. And so, always looking forward to the challenge.
Okay, thank you. MLA Reid, do you have a question?
Thank you so much, Madam Chair. Thank you for having me here this evening as a guest. And thank you so much, Chief Superintendent, my apologies, for your presentation. So for me, as someone who is not a part of this committee, but is interested in this topic, your slide on the concerning amendment, which is 18.4, sorry, sub 4, there seems to me to be two parts of the legislation, right? So there's the part that says decline to publish, and then decline, well, it doesn't say it exactly, but it's also saying decline to provide it to an authority. And it seems your piece is really just the part that's declined to provide it to the authority that you have the problem with. So I guess to my mind, and to build on Mr. McNeely's question, if the part where provided to an authority was removed or amended in some way such that it was provided confidentially to the RCMP to make sure that you're still having access to these records, to make sure that you're still able to maintain your databases, would that be sufficient? Thank you.
Okay. Thank you. Chief Superintendent?
Yes, absolutely. If that was already in there, we wouldn't be having this conversation, as much as I like coming here.
Okay, thank you. MLA Reid, do you have a follow-up question?
No, I think that really clarifies it for me, and I thank you for your time, Madam Chair.
Okay. At this time, if there's no more question, then we will switch our witness to Northern Mosaic Network.
Thank you, Madam Chair.
Thank you.
We'll call meeting back to order.
Oh, there we go, take charge.
Yes, okay, we'll start with the introductions, please, or chairs back to.
Okay, starting to my left. We'll do, okay. Oh, sorry, I do apologize. Okay, go ahead, please proceed.
Thank
with your
you.
presentation.
Good evening, Madam Chairwoman, committee members, guests, and other legislative staff. My name is Chelsea Thacker. I'm the Executive Director of the Northern Mosaic Network. My pronouns are they, them. And I've been in my position for 9 years. This is actually nearly 10 years to the day that we last spoke on the Vital Statistics Act. So it's an interesting time to be back here and speaking on some of the amendments. Hoping to provide some clarity tonight on some feedback we already provided, as well as answer questions and see a path forward that can speak to all of the residents of the NWT and making sure that they feel seen, heard, valued, and empowered to be their authentic selves. I will pass it to Emily.
Hi, my name is Emily Smith. My pronouns are she, her. I'm the peer support coordinator for Northern Mosaic Network. And I grew up here in Yellowknife. The last time I used the coat check, I was a page. And I'm here today because I do the work of supporting people in the Northwest Territories through a peer support program, which often involves things like helping people fill out change of name paperwork, like go through these different processes. So that's my connection to this.
Ani, my name is Lindsay Dubosky. My pronouns are she, her, they, them. I'm a Two-Spirit Chigi and Anishinaabe, born and raised here in Sambake and Denende. I am the Executive Director for Community Camp NWT. We provide online programming for Two-Spirit, Indigiqueer, queer, and trans Indigenous people in the North. In addition to our programming, we also feel a very strong need to advocate for our 2SI Q-tip. That's a word that I use for my community members, people like me, here in the North. And advocating for their needs to be seen, heard, and held by their communities. And a big part of our organization is being able to bring those folks and allowing them opportunity to reconnect with the land, culture, and community, in the hopes that all Northern 2SI Q-tip remain home and they don't have to leave. They can stay here. See.
Thank you. Yeah, proceed with your presentation.
Great. So first, just a little bit about why Bill 40 matters to the 2S LGBTQIA community. Vital Statistics Act and the Name Change Act, which Bill 40 seeks to amend, govern gender marker changes, name changes and how families and name changes and how families are recognized on birth certificates. These things all impact the safety and well-being of many 2S LGBTQIA youth, adults, and families. For some Two-Spirit, transgender, and gender diverse people, changing their name and/or gender marker is an important way to express and affirm their gender and has a direct impact on their safety and well-being. For example, some trans people having a name and gender marker that matches their gender presentation allows them to choose how, when, or if they disclose that they are trans based on the situation and how it might impact their safety. So, and as the slide says, the act, we want to make sure that we're supporting 2S LGBTQIA youth, adults, families, and those who don't have the ability to be here today to speak for themselves.
And just like a reminder for you folks, the GNWT has made.
Wait to be recognized, please. Are you done with your presentation?
Yes, thank
Okay.
you. Sorry about that.
Okay, please go ahead, Executive Director DeBassi.
I will.
Yes.
Okay,
Go.
sorry. Let's see. Yeah, so the GNWT had, you've made commitments to implementing the TRC calls to action, to UNDRIB, to missing and murdered Indigenous women, to and girls and two-spirit folks and calls to justice, you know, and within these commitments that we've also committed to protecting Tuasai Q-tip, these two-spirit, indigiqueer, queer and trans Indigenous people of these lands, that, you know, we as Tuasai Q-tip are inherently traditional. We are, our identities are traditional, and they deserve to be valued and seen by our community members as the rest of everyone else. You know, we have a spot in the circle.
Okay, thank you. So, Executive Director Thacker.
Thank you. I will do a better job of indicating who's next to speak, because we have these notes, but I'm aware that you might not have who goes next. Apologies for that. Thank you for your patience. Okay, so our stance on Bill 40 is that we actually support many parts of Bill 40. We think that a lot of the amendments that are proposed are beneficial to our community, and they fit with the more modernization of the Act. This includes allowing up to 4 parents on birth certificates, increased rights for 16 to 18-year-olds, the option to request a birth certificate without sex information, the introduction of a certificate in change of gender, and expanded criteria to request that name changes are not published in the NWT Gazette. We are proposing changes to Bill 40 to increase its positive impact, address existing issues, and mitigate potential harms to 2S LGBTQI people in the NWT. Not only are we looking at today, but it is our job to look to the future and to anticipate how maybe certain language in the bill could be used, not with this sitting assembly, but years from now. If someone were to interpret the language as it stands in the amendment, that might pose certain problems for our community. I'm also going next, so for the next slide, so I'll just keep going. Thank you. The language that we chose to use is not neutral. It can be used to include or exclude people. 2S LGBTQIA youth, adults, and families exist and will always continue to exist in the NWT, even if we are not recognized by the language in these or other acts. Using language that is inclusive of 2S LGBTQIA people ensures that we are accurately describing the diversity of people and families that already exist in the NWT. This isn't new to us. We already know. This is just more making it official on paper and in law. However, when the language that we use excludes 2S LGBTQIA people and other marginalized communities, we exist without equitable recognition and access to legal protections. So by refusing to explicitly name, sometimes we actually pose more risk. In an effort to be inclusive, sometimes we can see, we might strike everything that's related to this one topic to provide a protection, but it might actually take away from any protections available or grounds to stand on. In the next slides, we'll highlight 4 ways that we believe Bill 40 can use more inclusive language and promote equitable recognition and protection for NWT residents of all genders and sexual orientations. I'll now pass it to Emily for the next 4 slides.
Is Coordinator Smith, please go ahead.
Thank you. So as Chelsea mentioned, I'm going to speak to a few specific examples of language in Bill 40 and in the acts and how that can impact people. So the first one is a suggestion to change gendered pronouns in the act. So for example, in the act currently, there's a lot of the registrar will make this change if he or she thinks it's correct to do so. Is an example. We're just saying you can say the registrar shall make this change if they think it's correct to do so, or if the registrar thinks it's correct to do so. So that's just in keeping with general updates that people are making across different legislation and across the GNWT to use inclusive language. The next thing related to language that we mentioned is talking about the definition of birth used in the act. So right now, the definition of birth used in the Act is very long, but it starts with birth means the complete expulsion or extraction from its mother, irrespective of the duration of pregnancy of a product of conception in which after the expulsion or extraction, there's breathing, beating of a heart, pulsation of the umbilical cord, or unmistakable movement of voluntary muscle. very long. So what we were saying is that right now, because it uses that wording from its mother, it's implying that only mothers can give birth to children. And we know that this isn't true. We know that transgender men can give birth to children and be a father and not a mother. We know that non-binary people can be parents and can be birthing parents. And we also know that not all mothers are the parent who gives birth. So to more accurately describe everyone who gives birth and include everyone in this language, we're suggesting updating this definition to focus on parent or birthing parent. And there are examples of this in both Manitoba and Ontario. They've updated the definition of birth in their acts, and it's just focusing on those few simple words. Connected to this, there's also definitions of parents in the act of mother, father, other parent. And these definitions are all connected to the words mother and father. And the way that the words mother and father are defined are in relation to who is giving birth. So mother is defined as the person giving birth. And we're saying this is a fairly limiting definition of mother. We know there are lots of different ways to be a mother, and you don't have to give birth to be a mother. So we're suggesting when we're looking at the language around parents that we can just say what we're talking about, which is parent or birthing parent, if we need to specify that in a certain situation. And again, Manitoba's Vital Statistics Act has done this, and they've made this language update throughout their Vital Statistics Act to make sure that they're including everyone in it. Oh, to Lindsay.
Okay, Executive Director
Oh.
Debassi.
Yeah.
Oh, okay.
Yes, thank you, Mercy. So your current definitions of mother, father, and birth, they're enforcing these like colonial family structures, and they're not reflective of the Indigenous family structures. You know, many Indigenous families are like encompassed by individuals who maybe are aunties or uncles. And I think something that unfortunately I see with the youth that I work with, young two-spirit queer youth, is they're being raised by people that are external from their family unit because of the homophobia and the transphobia that they experience at home. That is where they found safety, and that is how they're surviving right now, you know? So this language is a barrier for them in feeling seen and heard in that. And yeah, the updating these definitions to recognize the diversity of Indigenous family structures and making sure that we're honoring and putting forth language that is, you know, traditional and tied to the Indigenous peoples of this lands. Merci.
Okay, thank you. To Executive Director Thacker.
Thank you, Madam Chair. So to clarify the use of gender versus sex, so there's a lot of definitions and terms in the Act itself that I think could have used a lot more clarity. And perhaps it's also that these definitions have evolved over time, and as all language does. So just to kind of point out that the terms sex and gender are used inconsistently and interchangeably throughout Bill 40 and the Acts. For example, when you apply to change your designation of sex, you can receive a certificate of change in gender as a record of this change. As we kind of like provided in the glossary ahead of time, sex is something that's designated at birth, and gender is who you are and how you move through this world, how you want to be seen. So it's not necessarily biologically related, but it has so much connection to who you are as a person that it also deserves to be seen, and it has its own definition. So In order to provide the clarity that this act and the bill needs, the act should differentiate between sex, gender, as well as associated terms like designation of sex. So we've provided some terms in the glossary as well as information in our feedback that hopefully provides a bit more clarity on how these terms should be used. It's just a recommendation. You obviously have so much feedback to consider, but just as the organization that primarily does a lot of educating around this, this is how we've recommended that you move forward with a definition, if it feels acceptable. Based on our reading of the acts, it also seems like the term gender marker would most accurately describe what sex and gender are currently used to describe. So rather than having two different terms, we've proposed a middle ground that might be a little bit more easy to understand and applicable in legislation. And in situations where people are given the options of selecting M, F, or X, it is more accurate to call these gender markers instead of gender because M, F, and X are not genders, they're just markers used to categorize the genders overall. So obviously we only have so much time and this isn't a training class, but there's lots of different genders out there and there's a lot of information on how to organize who we are as people, though we are so vibrant and different independently in ourselves. Having simplified designations to be able to refer to different groups, it is acceptable and we're just providing a little bit more clarity on that. In addition to making the language more inclusive, we have a few other concerns we hope that Bill 40 can address. So our concerns are about access to personal information of 2S LGBTQIA people in the NWT and potential gaps in legal protections for 2S LGBTQIA people in the NWT. Sorry about that. I'll pass it over to Emily after Madam Chair so that she can continue with a few slides.
Yes, please proceed.
Thank you. So one of the other concerns we identified is around who has access to people's personal information. Because vital statistics records include things that can tell people information about people's gender and sexuality, because you have marriage records, you have name records, you have gender marker records. And one of the things that has been added in Bill 40 is a line about a member of a law enforcement agency in another country who requires a search certificate or certified copy for law enforcement purposes to the list of persons who are eligible to apply to access vital statistics information. So we're worried that in our reading of the bill, this means that law enforcement agencies from other countries that are not governed by our protections of people could have access to people's information, and that could create a serious safety risk for people that are living here, but that may be from countries where aspects of their gender or sexuality are criminalized. So that could be very dangerous for them if we are openly allowing international law enforcement, so law enforcement from countries that is not our own, to have access to that personal information. And so we're recommending to take that section out to prevent that harm. And back to Chelsea.
Yes, Executive Director Thacker, please proceed.
Thank you, Madam Chair. So, lasting protections for 2S LGBTQIA people. So, like I said before, it's our job not only to look at right now, but also to the future. We're concerned that open-ended language used in some sections of Bill 40, as well as sections of the Vital Statistics Act and the Change of Name Act, not amended by Bill 40, leaves them open to interpretations that could cause harm to 2S LGBTQIA people and to two-spirit, transgender, and gender-diverse people in particular. For example, in Section 12, subsection 2 of the Name Change Act, it states that the Registrar General may refuse to register a change of name requested in the change of name application if, in the opinion of the Registrar General, the requested name change might, 1, reasonably cause confusion or embarrassment to another person, or 2, be used in a manner that could defraud or mislead the public. Unfortunately, some of the language in this section overlaps with common transphobic talking points. So that trans people are confused about their gender, the concept of trans people is too confusing for children, trans people are misleading people by lying about their identity, trans women or deceiving people to gain access to women's spaces and to cause harm. All of these things are categorically untrue. And aren't even able to be proven statistically because situations that might happen in that realm are so incredibly rare. However, this kind of disinformation is often weaponized against the Two-Spirit, trans, and gender diverse community to restrict their rights. While we believe that this section was written in good faith, and we don't believe this similarity is intentional at all, we are still concerned that this section could be interpreted in the future in a way that would permit the registrar to discriminate against Two-Spirit, trans, and gender diverse people by denying their name change based on a transphobic interpretation. Increasingly, with things like the youth gender affirming care ban in Alberta, we are seeing the legal system fail to protect the rights of Two-Spirit, trans, and gender diverse people. While we don't think that it is the intention of the current government to interpret these acts in a way that could cause harm to Two-Spirit, trans, and gender diverse people, it is our responsibility to consider the potential future harm and advocate for stronger protections for our community. We need to address these potential loopholes to prevent them from being weaponized in the future and to ensure strong and lasting protections for 2S LGBTQIA people. And Madam Chair, if you could pass it to Lindsay, please.
Yes, please. Please proceed.
Merci. We also need to ensure that our legislation upholds the right to our self-determination as Indigenous people. And for 2S IQ-TIP, that starts individually. That starts with us. We have a right to self-determine our identity for ourselves. That's our choice. That's for us. And that goes into our communities. And we need to remember that and honor that. Self-determining our gender and our other parts of our identity is our inherent right. And we have right to belonging here. Yeah, and I think that's like open-ended language does not protect this right.
Okay, thank you, Executive, Coordinator Smith.
Thank you. So the last section that we wanted to talk about is the same section that the RCMP was talking about. So it's section 18, subsection 3. Of Bill 40, which confusingly is talking about section 14, subsection 4 of the Change of Name Act. So those are the two numbers we're working with. And this outlines the conditions in which the registrar can decline to publish a name change in the NWT Gazette. And it adds the condition that the reason for the change of name relates to the person being transgender, non-binary, gender diverse, or Two-Spirit Indigenous. And we really support the addition of this condition to make it clear that Two-Spirit, trans, and gender diverse people can request their name change is not published in the NWT Gazette, and that it recognizes that publicly publishing name changes and putting them in the public record can cause harm to people. We wanted to bring attention to the fact that this does not specify what information people will need to provide to satisfy the registrar that they meet this condition or any other conditions. And that's the language used in the Act. So we're worried that by leaving that very open, there's a chance that the registrar could ask applicants to provide proof of their gender or proof of hardship, because that's another one of the conditions to request that your name change is not publicly published in the NWT Gazette. And that this could cause harm to vulnerable people. That this could either cause harm to people fleeing violence, that maybe are requesting their name change is not publicly available as a matter of safety. And so if they were being asked to prove that violence, that puts them in a really tough situation. Family violence, intimate partner violence can be very hard to prove on the record. And while waiting for somebody to do that, it continues to put them in danger. So we just wanted to highlight that we need to think about what we are asking, what kind of information we're asking for people to meet these conditions. And we want to put forward that self-identifying, either disclosing that you are a person who having your name change published will cause you harm, or saying that you're somebody who is Two-Spirit, trans, and gender diverse and wanting to change your name because of this, and wanting to keep that information out of the public record that self-disclosing that should be enough information to provide to the registrar. So connected to this condition, I wanted to address some of the concerns that we've heard tonight and in other hearings about this same clause. So one of the things we heard as people talked about the impacts of expanding the conditions and concerns around safety and criminal record. And I think there has been some confusion here around what Bill 40 is actually doing and what we're talking about. So first, it's really important to clarify that in this clause where it's saying that the registrar can decline, they can decline both to publish a change of name in the NWT Gazette and provide it to law enforcement. Those are two separate steps. So what we're talking about today is the registrar being able to decline publishing it in the NWT Gazette. So if you don't know what that is, which I did not until I looked it up, it is a publicly available record. So anyone can go on the internet right now and you can read issues of the NWT Gazette dating back to 1993. And right now, all name changes are automatically put into the NWT Gazette unless you request them not to be. And the process to request them, to request that your name is omitted from being published in the public record already exists. And nothing in Bill 40 is going to change that existing process. I think this was something that MLA Morgan mentioned before, that the registrar has already been able to decline to publish names in the NWT Gazette. And I think the example provided in the RCMP's presentation of the notification of name changes is an example of how this current process works and shows that they can have access to this information without it being publicly published and available. So as I understand it, the amendments in Bill 40 really just clarify that two-spirit, trans, and gender diverse people can request that their name change is not put in the public record. And we thought it was really important to address this, partially because it is confusing, and I had to read through this a lot to wrap my head around it. But also because a lot of the language used in this conversation is very similar to language used in transphobic talking points that often connect transness to criminality. And those things are often weaponized against trans people to restrict their rights and to harm people. So it's our responsibility when we're hearing these things to point them out and to call them out and to try to provide some clarity around what is actually happening here. And just to highlight that part of the issue about two-spirit, trans, and gender diverse people's name change being published in the NWT Gazette on the public record is that means anyone has access to that information. And that means people can look back in that record and figure out that somebody is trans. And that might not be information that they feel safe sharing in that situation. And that might be information that somebody is looking up to cause harm and to hurt them. And so it's really important for people's safety that they can have the option that that is not published in the public record. And again, that's a separate process from notifying the RCMP. Those are two separate processes. Yeah. Thank you. So I'll pass it back to Lindsay.
Okay, please proceed.
Merci. You know, as community members that live in Denendeh, we have a commitment and we need to do our best to embody the Dene laws in order to resist gender-based violence. And I think when we think about gender-based violence, we're really forgetting about the two-spirit, indigiqueer, queer and trans Indigenous people in that experience, that gender-based violence. And, you know, the work that I do with community camp and the way that I'm able to provide space for folks here in Denendeh, I really get to have this magical week with these young people and really give them the love that they have been longing for, yearning for. And I think you, as people in positions of power, you know, you have the ability to make these folks feel seen and feel seen in just words, you know, and that is really powerful, and it stems beyond what maybe your current understanding of our community, and that's okay, you know. This language, this colonial language, is often used alongside disinformation, and it's weaponized against us to restrict our rights as Two-Spirit folks, and to uphold legislation and language that erases Tuasai Q-tip is continuing to enforce colonial values and actively contributing to the gender-based violence that our community members are experiencing. And I really hope you take our recommendations here forward, and know that they will have very, very big impacts. I think about all of the young people that I have the pleasure of meeting and sharing space with, and they know I get to do things like this, and they're going to be so happy. We'll see.
Thank you. Committee, are there any questions? Okay, MLA Reid.
Yeah, thank you. And I thank you for your presentation. I just, and thank you very much for providing the supporting glossary. Can we take it back a few steps and even just talk a little bit more about the difference between gender and sex? You talked about gender marker, but maybe just give like an overall picture of those three terms for committee. Thank you.
Okay, so we'll be Executive Director Thacker. Yeah.
Okay, great. Thank you. So MLA Reid, as I understand your question, just to kind of review some definitions. Great. Okay, thank you so much for the opportunity. I know these off by heart, but of course I'm a little nervous tonight, so I have my glossary in front of me. Okay, so as we've kind of described, assigned sex is that system of determining the biological sex of all living beings as it relates to reproduction. People are often under the impression that chromosomes and that data is what is used to determine sex and therefore assign a sex. However, our current system is typically based on the visual appearance of genitals only. So that actually omits many intersex people who who might not visually display a physical difference, but when assigning sex, they can be just automatically determined as male or female based on visual interpretation, and which can lead to many health complications down the road, and lead to a loss of identity as well for a superficial way of determining what sex is. But that's currently how sex is determined. Components of sex is, although people only think that it is our chromosomes and genitals that make up our biological sex actually encompasses 5 additional parts: your gonads, your hormones, your internal genitalia, your external genitalia, and your secondary sex characteristics. So again, speaking to the existence of and the validation of intersex people and their existence in our society, just wanting to further break that down. We have such a very limited understanding of sex and gender, and it is often told from a man's perspective, and how it's like physical health and these things have been determined for us by the patriarchy largely. Gender identity, as I kind of explained before, is a term that encompasses a personal sense of one's own identity in relation to certain terms like man or woman or non-binary, Two-Spirit, or any other cultural term that designates a gender. Gender includes roles, characteristics, forms of expression, traits, and histories of those who identify themselves in line with these terms. The roles, characteristics, expressions, traits, and histories that society has assigned to any gender may shift depending on the cultural and social context. This means that the meaning of gender is defined by a given society, and as these aspects change over time, the social construct of gender will also shift. I think we've also seen, even since pre-contact to contact and moving forward, definitions of things like man and woman, masculinity and femininity, those have greatly been altered by larger systems than any of us, like colonialism, that sought to really simplify and eradicate any difference, making it extremely difficult for us now to separate these things and call back to a time when people were allowed to have so much more freedom of expression and identity, and who they were in their community and who they are was just so much more than who they were born as. And in our look to the future, we also want to call back to the past and recognize that oppression of gender and sexuality was very powerful and rooted in a lot of shame. And that still continues to find its way into our conversations that we're having today. Our understanding of gender is so surface level because that's all we've been allowed to do. And I understand, I hear the feedback of this was never in our culture, this is not like part of our communities and those things, and I know I'm kind of going outside of the definitions, but I'm impassioned, so stop me anytime, Madam Chairwoman. But I think that we're doing a disservice to the young people who are telling us this is who they are, and by continuing to limit how they are defined in public policy and acts and legislation, tells them that their voices don't matter now, and they have to grow up a whole lot and go through a lot of harm before their voices can be taken seriously. And that's not the future that I want to fight for, and I don't think it's the future that our Legislative Assembly wants to fight for. So I'm imploring the committee, when reviewing this bill, that you take a look and understand that it's not just the adults and maybe communities that you don't fully understand or are not a part of. It's also our young people who are so brilliantly diverse, and they are just begging to be seen and heard by this Legislative Assembly in all aspects that matter and maybe don't even matter at the end of the day.
Okay. Thank you. MLA Reid, do you have a follow-up question?
I don't think I can follow that up.
Thank you very much.
I'm all right, thank you, Madam Chair.
Okay. Is there any, okay, MLA Morgan?
Thank you, Madam Chair. I know it is getting late, but I just wanted to make sure that we get a clear indication from you folks. So the RCMP's concern about still being notified, which you've been clear is separate from the issue of publishing in the Gazette. Do you have any particular objection or position on whether or not the RCMP is notified if someone changes their name for any reason, so that they can cross-reference, criminal records and this kind of thing, if it's not published publicly?
Okay.
Thank you, Madam Chair.
Thank you. Executive Thacker?
No, we really don't have any issue with that at all. And we do understand it to be two separate issues. I think at the end of the day, we'll never, for public safety concerns, we'll never get away from notifying the RCMP of name change when that happens, as the registrar can already determine whether that or not that does. So no, nothing to say from here.
MLA Morgan, do you have a follow-up question?
I'm just going to note really briefly, as we are discovering as committee members through this process, that while we want, or maybe we don't want, the significance of someone being able to change their name or gender in their birth certificate to sort of mean and convey all these things, it may not, at the end of the day, have much impact on people's rights or recognition or on matters such as, custody or parental rights or any of these things, because those things are actually found in other pieces of legislation. So even if you get, who the parents are named on the birth certificate, at the end of the day doesn't necessarily hold legal weight, later on when it comes to sorting out what happens with the child or who has rights over, that's all. So anyway, just to flag that there may be other acts that you're interested in, more work and advocacy. That this is not sort of like the one-stop shop for if we just change this Change of Name Act and Vital Statistics Act and get, then everyone's sort of rights become equal. Anyway, there's many interlinking legislation that has to do with, children's law, family law that all needs to be sort of taken apart when it comes to trying to tackle, like you're saying, colonial assumptions or assumptions that are sort of outdated now in terms of sex and gender and parenting. Anyway, but I'll just leave it there because that's for another night. Thank you, Madam Chair.
Okay, thank you. Executive Director Thacker.
Thank you. And yes, for sure. Obviously, the passion does come when looking to our young people because they are part of the Bill 40. And there seems to be, with all government, that concern about, providing more grounds for young people to advocate for themselves that can cause future concerns. So I definitely appreciate you being recognition is very important, but also this is not the grounds that you have to fight that on. And I do respect that of the work for the committee. So I am sorry that I went on such a long tangent, but yes, I definitely want to recognize that it is for the youth and the increase in them having access to things like the name change and having some of those barriers reduced is just very important for that recognition for sure. Emily, would you like to add something?
Yes, please.
Madam Chair.
Proceed.
I think that's such a good point, and I wanted to say that's why this is such a powerful thing to change and such a powerful thing to be mindful of language, because in some ways it's less complicated. We're not changing family law, and it's something that we can do that makes people seen in our legislation, seen and included for everyone in the Northwest Territories. Yeah.
Okay, thank you. Is there any more question? Oh, okay, yes, please, go ahead.
I just wanted to say, I think it's really important. I think all this is very important because it is then affirming and, supporting people's individual agency and autonomy, and especially as Indigenous people, something that has been stripped away from us time and time again. You have an opportunity here to enact a language, enact this bill that restores some of that to our people, and I think that would be really impactful. And we'll see.
Okay, thank you. Is there any more questions from the committee? Okay, I don't see any more questions. Thank you for the presentation. So I think, the committee would like to thank everyone for appearing at tonight's public hearing and for taking the time to provide this valuable information to the committee. So the feedback we have received today will be carefully considered in our review of Bill 40, an act to amend the Vital Statistics Act. So this concludes our presentation for this evening. Thank you.